And just like that, good morning, welcome back to Sunrise. Order, order, order. It is Sunrise right here on CVM, and a pleasant morning to all of you. Thank you so much for watching on YouTube, and do remember, when you're on our YouTube channel, please do hit the like and subscribe button, and always do remember to spread the word. I know that you guys are making your way out, but it's time for another segment of Law and Order JA. Now, the question this morning sent in by one of our viewers reads as follows. My name is Henry, and I work for a bank in New Kingston. I recently received a letter advising me that I was being terminated by reason of redundancy. This caught me by surprise because I know the company is doing well. I think I received this letter because I recently made a mistake at work that created some trouble for the company. Can I really be fired suddenly like this? I don't believe they are treating me fairly. Well, to help us navigate and distill all of that and the area of the law that with which we're dealing this morning is none other than attorney at law, Jonathan Morgan, partner at Duncox Attorneys at Law, and he's with us this morning for another breakdown of the legal jargons, the legal issues, and what is the remedy, if any. Good morning, Jonathan. How are you, counsel?
Good morning. I'm doing quite well.
Very well. Jonathan, redundancy. Where are we in the law this morning? Henry wants to know if he can be fired just like that.
Yes. Well, this area of law tackles two different streams. It tackles both employment law under the Employment Redundancy and Termination Payments Act and labor law under the Labor Relations and Industrial Disputes Act.
Right.
Now, those two areas are very similar, so they're easy to be confused.
Oh.
However, there is a distinction between the different categories and the different issues that arise under each. In this situation, it seems to be that the issue is more so under labor law, where Henry seems to be concerned about whether or not the reason for termination was valid and the urgency of that termination was fair.
Yes.
Under labor law, the companies are required to both have a genuine reason for termination. In this case, if it is redundancy, it must be due to the restructuring of the workforce as a result of some reduction in business or some relocation of business. That is a valid reason for redundancy. And they also have to follow certain procedures to ensure that the redundancy is in fact fairly implemented. Right. And both of those seem to be a little murky in the question raised by Henry.
Yes. So when he says, well, all right, so on the one hand, the unfairness of the redundancy. So when a person is going to be made redundant, what usually should be the process? So you can't just spring it on somebody. Do I have to give you what notice of what, 2 months, a month, 3 months? Because businesses will say, well, I might be doing well in your eyes, but we know things that you don't know, and we want to make you redundant. So how do they go about making somebody redundant?
That's right. So the process that they have to follow is a very involved one. It's one that they should seek legal advice on to ensure it's followed carefully. Right. But I can give a snapshot as to some of those requirements. First, the company must engage the entire workforce to advise that some restructuring is coming. Okay. They must notify the entire cohort that the company is reducing its business in this way, and it could have an impact on some of the roles held by the employees. After that widespread and company-wide form of notification, the company should engage with the individuals that are most likely to be affected. Right. Those individuals need to be invited to meetings, specifically meetings held for the purpose of consultation, so that those individuals can appreciate the impact that this potential change may have on their roles, and they may be given an opportunity to give their feedback before it is implemented. So consultation meetings need to be held with each of the potentially affected individuals before the redundancy decision is made and before they are handed a letter terminating them by reason of redundancy. Wow.
What about the aspect of the letter that spoke to the mistake that Henry made that caused trouble for the company? Is that anything that will work against him that the company could use in their defense?
So this is quite interesting, and employees tend to, if they hear that they may be made redundant, they tend to defend themselves immediately. So in this case, Henry is aware that he made a mistake and it could have caused some trouble for the company. And he believes that's the reason for the redundancy letter. The issue there is that companies are not able to terminate an employee as a result of that employee's performance or even as a result of misconduct if the reason proffered by the company is redundancy. The only legitimate reason that a company may terminate by reason of redundancy is if the company's business, as a result of its operational needs, is being reduced or diminished in such a way that the position is no longer required.
Right, so the position is being made redundant.
That's right. So, so what Henry should raise is, in fact, the allegation that some mistake is the real source of him receiving this letter is wrongdoing on the part of the company.
Right.
The company, if it is correct that they are terminating him because of the trouble that he caused for the entity, because of some poor performance or some misconduct issue, the company would be acting unfairly and the termination would be unjustified, since it's not a valid reason for redundancy.
Redundancy. What should Henry do then, Jonathan, in terms of getting an attorney? What is recourse?
Absolutely. So Henry's first line of action is to consult an attorney.
Yes.
He should seek someone who has experience in this area of law. That attorney will go through the termination letter to see if first the employment issues are met, they are satisfied by the terms of that letter. He is given adequate notice. He is given redundancy pay if he is entitled to it. That will be the first bit of recourse. And then the second bit of recourse for the attorney would be to consider the labor issues and to determine whether the procedures adopted by the company were proper and whether the reason provided by the company could be supported. If the reason provided, if in fact it's not a genuine redundancy and he was in fact terminated because of a mistake he made, the company would be perhaps in a bit of trouble as a result of that decision. And then if the company failed to follow adequate procedures, the company could also find themselves in some hot water.
Industrial...
yes, in fact, industrial action. So the attorney would advise Henry, if it is established on the attorney's investigation that the company did not have a justified and genuine reason for redundancy, and the company also did not follow the proper procedure, the attorney may advise him to take a few steps, starting with a demand letter to the entity, outlining the issue, demanding compensation, and if they fail to comply with that demand letter, commencing a complaint with the Ministry of Labour and Social Security. That's done by sending a letter to the ministry outlining the issue and raising what is known as an industrial dispute. And then it would go before the Industrial Dispute Tribunal. That's correct.
And all of that. Wow. I can see somebody at their house going, really, Jonathan? Really, counsel? I did not know that. And that is why it's so important to have a knowledgeable person like yourself come and explain to us. Because sometimes, Jonathan, the truth is we don't know our rights, unfortunately. And there are many things that happen in the workplace and otherwise, and people just take it and accept it because, you know, me never even know. Which brings me to my next and probably final question. Is this kind of issue statute barred? So, for example, somebody, this exact scenario that is happening to Henry has happened to Paula or Pamela or Carmen. But this happened 3 years ago. And now that I hear Jonathan on Law and Order JA saying this, oh, wow, I had a right. I actually had a cause of action. Me never know. Is it statute barred? And if somebody else has gone through this, is it too late for them to take action?
Absolutely. So there is a limitation period, so to speak.
Statute of limitation,
governing this type of issue. And that is a 1-year time frame. So it is a 1-year time frame from the date at which the cause of action arose, meaning it will be from the date of termination. So it is what, January 13th? So if someone was terminated in a similar way, at any point before January 13, 2024, they are out of time to bring a complaint before the Ministry of Labour. But any time frame or any date of termination between 2024 and 2025 would be within the limitation period.
Very well. See it there? You got it. Guys, I'm telling you. He's the boss. He knows what he's talking about. And is there any other advice you'd like to give to Henry as to what he should do to get on top of this issue?
Absolutely. I would just recommend to Henry that, of course, consult with an attorney, identify whether there are areas in which the company fell short, and seek to ascertain the cost of pursuing the action versus the potential benefit, the type of compensation or even reinstatement to the entity that you may be interested in. Once you've done so, the company should be able to provide cogent advice on the labor law avenues that should be explored.
Very well. Thank you so much, Counsel. And you
No
heard
problem.
it. Jonathan, please do keep your concerns, your legal concerns coming. We have very capable counsel to help you distill and to ventilate any issues that you may have. And you never know, your issue might be one that can help so many others as well. So please do keep them coming. Thank you so much, Jonathan Morgan,
My pleasure.
our partner at Don Cox Attorneys at Law. Coming up next, we'll tap into the heart of self-care right here after these messages. Please do stay with us.